This is Legal Luminaries. Join us as we delve into the inspiring stories of some of the greatest legal minds to have shaped South Africa's democracy and law. I'm Iman Rapetti, your guide through the series.
Judge Dhaya Pillay, what a pleasure and a privilege to have you join us today and be part of our Legal Luminaries series. You join a number of your colleagues who kind of had their start in the apartheid years in South Africa, a moment that really shaped and directed a lot of their careers. And it's similar in your case as well, because we know a lot of your pioneering legal work in the early years was around the time when the laws that were in place severely restricted the opportunities that particularly a number of non-white, as we used to say then, but Black South Africans found it very difficult to access and be included in the legal profession. And I really want to start there. You were joining us in this interview from Durban, and this is a place and a geography in South Africa that shaped you. Tell us a little bit more about those early years growing up in KwaZulu-Natal, what that was like, and some of the early influences that you had.
Thank you for having me on this program. It was not on my radar to be here, but I'm grateful that you've given me this opportunity. Durban has been my home. I love the humidity, and when I travel and come back, the hug of humidity tells me that I'm back home. So, yes, I was born here in Springtown, which is a working class rental area in those days. My parents also came from humble beginnings. My mother had to stop school after Standard 4, and my father after Standard 6 to support the family. But for them, education was everything, and it's the investment that you make that no one can take away. And with 2 girls in the family, that is what their primary goal was, to give us that independence through education. They were also members of the Unity movement. And so our political awareness, my sister and I, at the time, and now I have a brother, 13 years after my sister, was to give us that grounding about apartheid, to explain to us why we could not participate in the games on the beachfront and so on. And for that too, we as a family bonded, and we as children are grateful for that awareness. So, as you know, with the Unity movement were lots of intellectuals and lawyers. So although I thought I should become a social worker, they dissuaded me from that. They said I would have to work for somebody if I was a social worker, and they needed an independent daughter. And so the lawyers in the family, also Unity movement members, made articles, which was, I thought, going to be the impediment. Made it possible for me to serve articles, and I served articles with Mogea Mudlia, who later became a human rights commissioner, or he worked for the Human Rights Commission.
This was quite a unique start, that you were surrounded not only by a family who was invested in what was happening in the country politically, not only from a moral or philosophical perspective, but also in terms of their activism and the work that they did. For a lot of families, particularly in the Indian community, you either shut up and put up, or you did something about it, because those seem to be the 2 courses of action. And there was a high level, I would term it as conservatism in the community at that stage. So you were lucky in that you were in that environment, because for a young woman who's on campus at, I think they would call it UDW back then, University of Durban, Westville, taking part in student protests and being at the front line, in a sense, meant putting yourself at risk and also putting your future and your career at risk. How did you navigate that?
You know, my parents were, and I have only my mother now, were very feisty people. And my father's mantra was, if somebody tells you bread, you give them butter. And that was easy enough to understand. So we grew up in that culture, and, with the kind of reasoning and ability to work through debates. Apartheid was clear-cut, and there's just no way you could succumb to it. It was always going to be a fight. It was as clear as black and white. It's not as nuanced as it is today as to where in the spectrum between communism, socialism, and liberalism and conservatism, where one would fall. And there's so many ambiguities in between. And apartheid was something there where it had to be challenged, had to be overcome. My days at university were really boring because we boycotted the SRC. We couldn't have it. And so there was no SRC activity. And there too, our student activity revolved mainly around mass meetings, usually held off campus because we've had a very conservative university administration at the time. This was 1975, for 3 years thereafter. And of course, the Congress movement was coming alive at that time. You'll recall there was the 1973 strikes, a series of strikes, the railway strike, red meat, and a few other strikes happening at the time. Then came the Vihan Commission reports, which was about the time that I started articles. But I'm saying there was so much of political activity and intensity at the time that you couldn't miss it.
We've seen in later years, and we'll come to this in a little bit of detail during our interview, hearing about the diversity in the judiciary, transformation in the judiciary, economic rights. But a lot of your work centers around labor rights, and we'll talk about your role insofar as that is concerned. What sparked that particular line that you took? And one imagines that it does have its roots in the kind of activism that you were doing, this focus on labor and labor issues.
You know, 1979, I started articles. 1979 was also the year that the Vihan Commission report was published. And it was also a time when the strikes had taken its toll and something new had to happen in South Africa. The international boycott of economic, sporting, cultural were also taking effect. It was also the time, 1980, was a time when the Industrial Law Journal was launched. I didn't know it then until about 1989 when I walked into the library and the librarian said, "Oh, you've got 3 of your judgments published in the report." I said, "Oh, what is that? I've never heard of it." Okay, and then that's when I went and discovered the Industrial Law Journal. But it was also the time when the Center for Applied Legal Studies was established. That was 1978, under the leadership of John Durban. So it was the height of political activism at the time. These institutions, CALS and so on, organized seminars, workshops initially it was Detainees Parents Committee, Support Committee. I got involved in that because my partner was detained in 1981. There were also other conferences around developing the law. Administrative law was a big part of that decade, of the right to a hearing, the right to reasons. So every state action, we interrogated it about the right to fair practices, processes. So if someone was detained, well, Minister of Police, did you give reasons? What are the reasons? Whether it is in terms of the Internal Security Act, and much later it was the emergency regulations. If someone was refused bail, like Judy Butelezi, what's the reasons for refusing bail? And we applied to set aside the refusal of bail. And then, of course, that becomes a conversation. And then they realize, we don't really need to go down this road and refuse bail. Bail was granted. There were many landmark judgments over that period, that 10-year period. And labor law was beginning to take root at that point in time.
You, in many ways, have been trailblazing. And I guess it probably is a little bit of a mantle of burden, especially for the forerunners like yourselves, appointees to the judiciary, because when you were appointed in 2000, you've been now 24 years on the bench. You were one of the first Black women that were appointed to the judiciary. And there is that responsibility we have a constitution that was fresh, it was fledgling, something that we tooled in the post-democratic era, which is subject to a lot of testing because that's the beauty of a constitution. It's something that is organic. And the reflection is you have to, again, bring all of that institutional memory, that institutional knowledge into that position where there will be some tensions with the law as it exists and the changes that need to be made. How did you feel in the 2000s when that appointment was made into the judiciary, when you now wear this different mantle with a different burden of responsibility in your legal career?
I think we did what we had to do because we could and we had to. And so it wasn't a question of doubt. There was no one else to do it anyway. And I suppose my involvement, whether it was in any of the the committees that I became secretary to, the Release Mandela Committee or the Housing Action Committees, or later when Tito Mboweni appointed me as the Essential Services Chair, we didn't have an Essential Services Committee, and it was starting from a clean page. It just happened organically. And I think also, as I was saying, that writing and over time, the academic component and the curiosity about being better at what one was required to do gave me the courage and the confidence to take on new challenges. So I think I got appointed to the Essential Services Committee because my thesis, in my LLM thesis, that was a topic, and Tito Mboweni saw it, and he approached me to do that. The same with the public sector's work. And for about almost 10 years before I became a judge, I was in the panel of the Independent Mediation Services of South Africa. So that gave me a lot of confidence and experience that I knew I could do this. And I'm grateful to former Chief Justice Zondo. We were both on the drafting team, and he knew what I could do and took me into the labor court. There was none of the nonsense that came on later. Yeah. And I applied to the Judicial Services Commission. Just pretty straightforward. Arthur Truscott interviewed me, and that was that. So being in the labor court was just a natural transition.
So that was in 2000, and you've had this really incredible journey, Judge Pillay, in your legal career. In 2002, you were in the High Court, Western Cape Division, again making history there, one of the first Black women to be appointed to the judiciary. You took on that focus around labor law, constitutional matters, the protection of human rights. And this is something that you really became known for. If judges have a flavor, that would be the flavor that I would describe to you. Talk now about the labor court, and then moving on to the Supreme Court of Appeal. Shortly, we'll get to what happened in the Judicial Services Commission in those interviews, which were, I think, polarized South African society in a way about the way that you were treated during the Q&A process in those interviews for the Constitutional Court. And we'll get your reflections on that in a moment. But I want to go back to a theme that I raised in the earlier question. We're dealing with a very different context, a very white, very male judiciary in the post-apartheid era, to a judiciary that is different, that is changing, and you're part of those changes. I mean, just from a tonal point of view, I mean, how was that being a woman? Did you find that there were extra layers of challenge, extra layers of having to prove yourself, as we see with women in the corporate sector?
I think some of it is luck, and some of it was also the culture that I was able to thrive in. There are very few judges, for instance, who were and at that time, very few attorneys. I just started practicing, but I was one of the few, along with Ray Zondo, along with Azar Kachalia, who were invited to CAL's judges' conferences, long before the idea of being a judge ever confronted became a possibility. Not even the possibility of freedom in our lifetime. We were still sort of waging the war on the legal front and finding ways of challenging. So I grew up in this nurturing culture of creative thinkers and people in the academy who realized that there's got to be a succession plan after the likes of Arthur Truscott, Pius Langer, Ismail Muhammad. All of these people were our mentors. We practiced under them. They brought the many groundbreaking judgments that are still precedents today. For instance, if you want to use recordings of a meeting, you've got to show a chain of evidence. And Judge Moon threw out a huge terrorism treason trial on the basis that the recordings of those meetings were inadmissible. And that is still good law today. And there are many others like it. So firstly, it was a nurturing environment. Secondly, it was also the consciousness that one has to be curious always as a person and innovative. You've got to learn to innovate and have the courage to innovate, to make mistakes and learn from them. You have to push the boundaries if you're going to make a difference. If you're going to be saying the same things, then you're not going to do a PhD that's worth reading, for instance, or even write a paper, because especially now when you have internet and chat GPT, whatever it is, you know, all the information is there. What are you adding that will make a difference has been something that the people I worked with constantly drove me to look at. So you've got to be a person of substance. And so, you know, you can have the gift of the gab and you can write and tell good stories. But if you can't innovate and come up with a new idea, then it's not, your durability in society has an expiry date, let's put it that way.
Wow. And you certainly had that, you know, that durability over the last 24 years or so, I would say. When people think about cases in which your influence was felt, and I'm going to ask an unpopular question because I asked it of Justice O'Regan as well, not too long ago. And it's a difficult one to ask, and I've asked it to some of your other colleagues as well, of cases that really kind of stand out in your mind. It's very difficult to isolate one or two because different cases resonate for different reasons. But if you look along the landscape, I mean, labor disputes involving worker unions, you handled a number of disputes between workers' unions and employers. And you really emerged and seemed to be emerging on the side of those who'd been unfairly treated or exploited, dealing with discriminatory employment practices, for example, in the workplace, particularly those related to racial and gender equality. And what was stark there is, in your rulings, there was really this desire to hold companies and organizations responsible and accountable for discriminatory behavior, particularly when it comes to hiring, promotion, and this contentious issue of pay equity. So in advancing the causes of women in that one particularly, you can see that there certainly was a lot of impact. And then a number of other different ones. Is there an area where you think that you, from your vantage point, have been particularly influential, or anything that really stands out for you?
Let me talk about two things that's important, currently important to society. The first, disability and the rights of people with disability has been something that I have been very close to from very early days in the labor court. A woman who lost her job and was reinstated, but not properly accommodated. Standard Bank was the case. And they basically tried to work her out of a job. But more recently, I was in the Constitutional Court, and the case of Damons came up. Damons was a fireman who was instructed unlawfully, it seems, to be carried up 2 stories. And the usual practice for these drills was to carry a dummy. But Damons was carried on somebody's back, dropped 2 floors, broke his back, and there's this 40-year-old, strong as hell, now not able to carry weights in excess of 10 kilograms. I was the scribe in the judgment, and I said, I found in favor of Damons on the basis that South Africa had subscribed to the international standard on people living with disabilities. And that standard had shifted from our initial signing of it, pre-democracy, to now, when it became not a welfare piece of legislation, but a human rights instrument. And so that is the interpretation I gave. I didn't carry my colleagues along with it, but I felt that there was enough room in our Constitution to allow us to apply international law, even though we hadn't actually domesticated it. And to my surprise, I got a call from a representative of the South African Law Reform Commission. Would I help draft the legislation to domesticate the international law on people living with disabilities? They had been sitting with it for 5 years and didn't have a draft to produce. So that is the first thing that stands out for me. The second one, which is topical now, is about whistleblowing. And a public servant, Mr. Chichongo, who was in charge of the Master's office, was told by the then Minister of Justice that he must impose or use Mr. Enver Matala in all the cases where liquidators had to be appointed in insolvent estates. The Master's Office had a program of having a panel and appointing people on that basis. He was disciplined for not listening to the minister. He was fired. He was reinstated by an internal disciplinary inquiry. They took him back, gave him a chair and said, "Right, you shall do nothing." And eventually he left. The persons responsible for that state of affairs was both the then minister and the Director General of Justice at the time. You can find the names, they're quite easy to find for that period. And it's in my judgment. So Mr. Chichonga comes to me for relief and remedy, and I awarded him 12 months' pay. Why? Because the only evidence before me was Mr. Chichonga's and one other witness who worked in the department who corroborated him. The minister and the Director General didn't show up, which I think is such a travesty of justice. A judge was appointed to make inquiries into the conduct of the minister at the time. That judge has since been charged criminally in a different context for trying to bribe participants in an arbitration. So Mr. Chichonga lost his job, was never employed again in the public service, and we know that the Master's Office remains in a mess. So those are two things that continue to trouble our society, two situations, two human social factors that plague our society, and I don't know whether there is a political will to shift the needle to make life better for people in deceased estates and people with disabilities.
In your mind, I mean, there's two things I want to talk about out of what you've just shared with us, but in your mind, what can change? Like, what is the scope for the law to be, to evolve, but also for there to be more accountability when it's seen to not work?
Well, look, you've got Babita subsequently, and she died, and others have left the country. Now, it can't get worse than that. And there's still no one arrested and convicted for her murder, as far as I know, unless that things have changed in recent times. But to my knowledge, if there's no political will, I don't know how one begins to remedy this. It's not in the hands. Civil society is doing its bit. Prosecutions are slow. Police are stretched. That's when they're not inept and corrupt themselves. Unfortunately, we're seeing a little bit of a cleanup, and hopefully it gathers some traction. But I'm afraid, the story of Mr. Chichonga and Babita are just the tip of the iceberg. Lots of people actually don't blow the whistle because of the repercussions for them and their families.
It's interesting you say that, because in recent days I've been doing interviews with different people who manage organizations and support groups for whistleblowers. It does come at a very, very high cost. The second part of what I wanted to ask you out of that story was, how difficult is it, and what challenge do you feel personally when you bringing a dissenting judgment, when you may not agree with your peers? And that's the importance of having, for example, on the SCA or the Constitutional Court, where there are multiple people, more than one person, who contribute to a judgment for that specific objective to create balance in that. How does it feel, especially when you're in the minority dissenting?
The sense of what is the best outcome, not necessarily the right outcome, because after many years in practice, there's no right or wrong judgment unless it's an irrational judgment. Because once you get your facts right, once you know what law to apply, and you apply the law to the facts, and you get a judgment, reasoned, then it is a judgment. So it's not a right or wrong thing. It's a question of what is the best outcome for a particular, and you feel it in your bones, and then you put it as physically as that. There's just no way. You do think differently. You try to think the other side and find holes in your story, whether you're writing for yourself or whether you're writing for the panel. You always test your views. What if I go in this alternative direction? What are the impediments to that? And then you come to a conclusion. It's not, there's a to and fro that goes between for and against this or that party in the hard cases. Some would tell you that, and there was this industrial court presiding officer, Arthur de Kock, in the early days when I practiced there. When we spoke, he said, you get a gut feel. I wouldn't like to say it's a gut feel, but there is a sense of your personal sense of justice, that it is still your personal sense that may or may not gel with what the law requires you to do. And so in one of the first full court judgments that I wrote the judgment for, it was, I think it was the case of Mr. Hall, where it came on appeal. And I had two male colleagues with me. And the question was, did he murder his wife or did his wife take her life? And the circumstances were such, you could find either way. And you could reason it out in both ways. And the question I repeatedly asked my colleagues, could it have happened that she shot herself? Yes. Then there's reasonable doubt. Even though you feel that, I'm sure he killed her. That's not what we do. We have to apply the test, and that is there reasonable doubt that she took her life? It's a very similar thing that plays out in this movie that's come up, The Accusation, in a rape trial. It's a very good movie for everybody involved in rape cases and how the judiciary works and so on. And particularly also for the judges, because it talks about the dilemma of parents, of the accused, of the accuser. And it was a very narrow set of facts that the court had to work with to decide whether the person is guilty or not. And when you apply the test, guilt beyond a reasonable doubt in that situation, which is what the defense also asked the court to do, the legal principles, that's what we're trained to do. And I can't say that even after I retired in 2023, January, but even then, I can't say that the hard cases become any easier. And when they have ramifications beyond the parties, you really have to think very carefully. And the tough cases where where you have several legal principles which are equally applicable, but possibly with different consequences, you have to choose those applying legal skill, knowledge, experience, and life skills.
I really, really love this conversation and the direction it's taking, because there's so much humanity to what you're saying, Judge Pillay. I mean, the outside world views judges, we think of Lady Justice, we think the law is blindfolded figurine with the scales in her hands, and that it all is really, really black and white, and we understand the letter of the law. Where's the room for the spirit of the law? And what you're talking to us is about what makes a good judge is having this composite of so many other things, which are not necessarily black and white, but which still have to be subjected to the black and white. So I just think that that's such a fascinating balance.
Well, I think that curiosity about how judges make decisions, I found helpful reading an article by Duncan Kennedy, who was emeritus professor at Harvard Law School, with whom I had the privilege of having at least 5 more than 1 hour sessions when I was reading for my doctorate. And he wrote this article, Freedom and Constraint. And he wrote it at a time when he was serving as a clerk to one of the Supreme Court justices. He had an imaginary case and he worked through the issues, the ebb and flow, the cut and thrust between for and against in a case, and how you come out at the end of it. And so that helped a lot. And one of the things that Kennedy brought home, people say that politics, ideology, and so on don't play a role in how judgments come out. But for me, what is it that makes Judge A choose 1, 2, 3 facts and Judge B X, Y, Z facts? Or 1, 2, 3 issues of law and X, Y, Z issues of law? that permutation gives you different results. And in the spectrum that I mentioned earlier on, between conservative on the one side and communist on the other end, there's a variety of ideological positions. And those choices are reflective of one or other of those choices. I'm not saying it's not pinned down that if I found in this direction on this case that I'm necessarily a communist, but a number of cases of that kind would show you might be able to pin me on that spectrum. But again, it boils down to applying the law to the facts. And different people choose different facts. Life experience does inform who you are. And I do wish the Judicial Services Commission would put a question in their interview. What book made the best or the most graphic or deep impression recently or when you were growing up, and so on? I think that would start a conversation about the kind of judges we are going to be appointing, who they are, and what their constitutional perspectives, what their life experiences are, what their worldviews are.
That's really fascinating. I was going to come to the JSC later, but let's come there now because you brought up the issue now. And I think what you're saying is really, really powerful in the way that we can evolve and make and create more nuance, especially in these really, one would say, almost hygienic situations and clinical situations where we're talking about competencies and judgments and track records and those types of things, to bring in these kinds of questions which create and show us a different side and dimensionality to the judges who are going to be making very, very important decisions about all of our lives, essentially. And it wasn't a particularly happy outing for you then. I'd love your thoughts about it. Of course, in your interviews to the JSC for consideration as a judge on the Constitutional Court, the highest court in our land, the entire public was part of those interview processes. It was beamed live into lounges and boardrooms across the country. There was a lot of criticism afterwards. People like KSAC, for example, an organization that is in defense of democracy, was basically calling out the JSC commissioners for failing during those interviews in the tone and style in which they managed those interviews. They were saying, at best, commissioners asked irrelevant and nonsensical questions that prejudiced the candidates, but at worst, they used the interviews for naked political point scoring. There were some criticisms as well that were leveled at you from different political parties. And I would like your thoughts on going through those moments in a time where you're applying for a really, really serious appointment where ostensibly what should matter is your ability to be able to do the job and bring that experience to the job. You're taking this unexpected turn for you. I don't know whether you anticipated it or not. Just walk us through what you were feeling and thinking during that time.
The JSC was one of the institutions that was captured over time, populated by people who had interests other than the work of the Constitutional Court and the judiciary in securing our constitution and our constitutional democracy. So for me, as much as I had great experiences in my working life, it was disappointing that both my appointments to the Supreme Court of Appeal and to the Constitutional Court didn't materialize. And I'm so grateful again to former Chief Justice Ray Zondo for giving me a year in that court just before I retired. So I had that experience and I'm grateful for that. But, when I got into the JSC interview, I knew pretty much in the first 2 or 3 minutes, 5 minutes, whether I was going to be shortlisted or not. And the antagonism I got at 10 o'clock in the night when I was called to this interview for the SCA was from the erstwhile Supreme Court of Appeal president, who recalled my previous interview about my answer to the question, why was I not appointed or invited to act? And I said, you should ask the leaders of the court. It's not for me to answer. And he started with that. Then I knew the Supreme Court of Appeal president is asking me this question, I'm not going to be appointed. And bear in mind also that it's an interview that's taking place at 10 o'clock in the night. When I was scheduled for the following day, it was a Monday also, and the weekend was spent celebrating another judge's 80th birthday. So I wasn't exactly firing on all cylinders. But coming back to the final interview, I didn't take it personally, actually. And this was the game, politics that was playing out. And for me, the challenge was to focus on the questions and make my points that I intended to make and not be derailed by the nonsense that came out. And questions even from the former Chief Justice, highly inappropriate and showed an agenda. But I think I'm truly grateful for civil society, for CASAC and the cases that they brought up, and particularly in my defense, I was not going to do anything about it. And the record would speak for itself. And it did. And I'm grateful that it was a turning point for the JSE and things improved thereafter. You know, the other thing is, I spoke recently to somebody from there. When the JSE started, there was a high level of collegiality and consensus about suitability of candidates. So, for instance, it wasn't so rule-driven that you had to have a regulation for every step of the way. Now it is no move is made unless you can pin it down to a regulation or a rule. For instance, in the old days, it was generally accepted that if you didn't act, and also if you didn't put out a judgment, then you weren't shortlisted. Now, everybody, the last shortlist is extensive. And so it's also not fair to candidates who have no hope of being appointed to go through the motions just because there isn't a rule to shortlist them out of the process. A candidate applying will not know who all the other candidates are until the shortlist is produced. It's up to them then to withdraw and so on. But it's not fair to raise the hopes.
So it sounds like there is some, reform that needs to happen in that space as well. You've not shrunk away from being very firmly in the public eye. And we've seen that with, whether it is your rulings around Judge Nkola Motata, for those who don't remember, convicted of drunk driving in 2009. But he wanted to have the Judicial Conduct Committee and Tribunal that was established to investigate him declared unconstitutional. But your judgment basically blew, that prospect of his out of the water because you dismissed his application with costs in that matter. And then we, of course, know with regard to former President Jacob Zuma, you had expressed you were left with no choice but to issue an arrest warrant after he had failed to appear in court. These are cases that intersect, especially in Mr. Zuma's case, with the politics of the country. So you bring an entirely new cohort of criticism, let's describe it like that, into your space. I mean, were you prepared for that sort of thing? And how do you prepare for that sort of thing?
No, I didn't. Look, Colin Matata, I was prepared for because Dunstan Mlambo from Gauteng needed a judge from another division, and he invited me. So that was fun. And it was fairly straightforward in the sense that the record was there, and there was no debate about whether he drank tea or whether he drank something else when he rammed into a wall. But it was interesting to write that because it was also having to look at international law on impeaching judges and the removal of judges. But both the Zuma cases that I sat alone, I'm talking about the Hanekom judgment and the criminal medical certificate one, I had no forewarnings of them. I just finished my out-of-town duty and finished a day earlier, and I was looking forward to a free Friday to catch up on admin. And the judge president walked into my chambers and he said, "There's this file, what do you got tomorrow?" I said, "Well, plan to do this, that, and the other. So, well, there's this application. It's probably going to be adjourned. What is it? It is a matter of Hanneken and Zuma, the defamation case. It's going to be adjourned, he said. Okay, it's a big fat file like that. And counsel came the following morning from Johannesburg, 2 senior counsel. They see me and they say, we're ready to proceed. So when the papers weren't, if you wanted to fuss about them, a judge could have fussed about them and said they weren't properly paginated. But you've got counsel, senior counsel from another province coming and they say that they're ready to proceed. And I said to them, I got this file yesterday. I haven't read it. You're going to take me through it. And we started the case. And I gave my judgment in due course. So I wasn't prepared for it. I didn't choose the case. I was saddled with it. Then I was assigned because of being on the Independent Electoral Commission in latter days of my time in the High Court. I did a lot more criminal work because then I can manage my diary. And then I was assigned to Pietermaritzburg Criminal Court. I, coincidentally, you might say, became the senior judge. So on this occasion, when Mr. Zuma was applying, his case was going to be adjourned. I was to take that case. So when I look at it, okay, counsel, senior counsel, the whole big team comes along. Mr. Zuma wasn't in attendance. He was unavailable due to his ill health. And the medical certificate was produced. So adjournment and account of this medical certificate. And I looked at it and I saw some alterations. And I said, well, who's going to authenticate this? And the contents of it was also curious. So that's what I did, what we normally do. If a medical certificate doesn't satisfy the requirements of a medical certificate, then you issue a warrant and you stay it for 14 days until the person gets an opportunity. I was still quite, unaware of the brouhaha, because between the court and going upstairs to my chambers, the social media was all over the place. And my registrar said, what have you done? I said, I don't know. I gave this order. And that was it. But it was just doing my job the way I was taught to do it. And it's the only way you can do that without getting sacked and becoming a football in the politics.
I only wish we had more time to press on this issue, but we are completely out of time. Judge Dhaya Pillay, what a pleasure and a privilege to talk to you today. And it's been such a fascinating conversation. I wish we had 2 hours because there are lots of areas I would have loved to have gone into a little bit deeper. But I think you gave us a really good topographical view of what has been a really interesting and multifaceted career. Thank you for your time today.
Thank you, Man. And thanks you for your team for the patience in setting this up.
You've been listening to Legal Luminaries, a Jackpot original podcast by Juta and Jacaranda FM. I'm Iman Rapetti. Find more episodes at jacarandafm.com. Just click on Jackpot.